back to Block TV, time for Cryptonomics and that fallout, if you can call it a fallout, and tidbits coming out of the Telegram hearing of last week, which, as we all know, ended with a promise to be concluded by April 30th. Now, to remind unsuspecting viewers, the entire Telegram open network and Graham saga began when the SEC filed a complaint back in October 2019 alleging that the company's sale of approximately 2.9 billion Graham digital tokens was in violation of the Securities Act of 1933 in the United States. But there was also something hidden in the small print of that filing. Asha Westrop Evans joins me in studio with that nuance that is making waves in some of the Sphere's headlines today. Asha, what is it all about?
All right, Yael. So this comes to us, this sort of point of nuance comes to us from A16Z, the crypto venture capital firm, which did a very interesting write-up talking about this unique problem that's actually being faced within the Telegram case that extends far beyond Telegram, far beyond the crypto space, and in fact into equity markets as a whole in the United States. Now, the article sort of breaks down sort of the key concepts here, but I'll take the highlights for us. Pretty much, there's a key point of US securities law, which is that in the US, securities need to either be one of two things: registered with the SEC, standard sort of thing for the vast majority of securities, IPOs, follow that model, etc., or sold under very special conditions to accredited investors. Now, we've spoken a lot on this channel about accredited investors in the past. It's a common topic of conversation in the crypto space, but accredited investors usually mean institutions that are considered sophisticated or high net wealth individuals.
I was about to say anybody who makes above 250,000.
Exactly, exactly. So those are sort of high net wealth individuals that are considered sort of secure enough and knowledgeable enough to be able to invest in riskier assets. Now, there is an exemption to that rule, though. The Rule 144, it's known as. Which allows these accredited investors to buy and sell these exempt assets, these things that are not, these securities that are not fully registered, under the principle that they can then, once they've fulfilled a certain number of criteria, resell those assets, as it were. So that's a typical. Let's give a typical example. In a Series A funding round, a high net wealth individual or a venture capital firm wants to invest in a new company. They want to buy some stock in that company, but it's not being registered with the SEC yet. They buy it, and then later down the line, they can resell that to the public because it's fulfilled the criteria. It's existed long enough. It's proven its fidelity.
It's proven its
Exactly. And if it meets these certain conditions, but mostly a matter of time, it can be resold. Now, the trouble is that is established case law in the US since 1970s, 50 years of established and settled law on this matter.
Right.
But this SEC case against Telegram actually throws that into question, that Rule 144 into question, because it implies that these tokens, which were sold under an agreement that they would be securities that will be later deemed not securities later on, that same principle could impact the way in which venture capital firms and other big investors in this level invest in these products and tools that they later want to sell for profit. Because a big point underlying the SEC's case is that the companies only invested in Telegram with the principle that they would later make profit.
Right.
Which is generally a fairly accepted principle of investing.
Why else would you invest? It shouldn't be shocking to anybody.
It should not be shocking to anyone, but the SEC's case says that these investors serve more as underwriters, much like an investment bank that underwrite the initial project, and therefore should have a lot more liability in the case. Right. If Telegram does something wrong, the investors should be liable, the sort of thing that most investors want to avoid, having that sort of liability on their books when they're investing in something that they do from the outside and they're bringing capital into it. So really, this is an amazing, subtle and nuanced point about this that sort of blows this case into a much larger frame.
It really makes me wonder. It makes one want to pick up the phone and call the Telegram lawyers.
Right.
And say, look, apropos, if this is being headlined right now within the Sphere, I'm assuming that would be an argument in court. One could wonder.
Certainly. I mean, this is the sort of thing that's being sort of brought up by Telegram, by the SEC. I mean, it seems to have been largely ignored in the SEC case until now. Right. This wasn't sort of the direct point of contention necessarily in the case, but sort of a byproduct of where this conversation is going. And a key point to the fact that the Howey test that comes to us from the 1930s is now being tested under conditions that it was never intended for. In 2020, it is beyond the scope of what anyone in the 1930s was thinking about.
Exactly. I mean,
what is a business security.
And at a grander scheme, and in a macro look at things, not just for the crypto sphere, the Howey law should in any case be revised. We can argue that because things that were written back in the 30s or 40s of the last century may be slightly outdated. But when it comes to the next phase, that would be what you just described. That would be actually an argument to be used by Telegram.
Certainly
right?
certainly so. And something that Judge Castell, the judge overseeing this particular case there in the Southern District of New York, would hopefully be aware of and be focusing of before laying down any sort of decision. But the fact of the matter is, at the moment, the case is on hiatus until a ruling that will be laid down before the April 30 deadline, according to Judge Castell. But what that actually means and what's being taken into account in this case remains largely behind closed doors.
But thank you for explaining all of that, Asha Westrup Evans. We were Block TV. We'll be right back.
For more news and updates, follow us on Twitter.